It's wintertime. It's a cold and rainy weekend morning here in San Francisco. We don't get a lot of weather like this, but it's a great morning to be inside answering questions and reading comments from my YouTube channel. Hi, my name is Carr Ferrell. I'm a Silicon Valley patent and intellectual property attorney. Welcome back to my channel. This first question is a copyright fair use question. It says, I've read that as soon as you have any profit off copyrighted material, fair use goes out the window. This would mean fair use wouldn't apply if the copyrighted material was used on a monetized social media page or channel. Is this true? Okay, first of all, a quick review on the doctrine of fair use. Fair use is an affirmative defense that can be raised against a claim of copyright infringement. The fair use defense, or the fair use doctrine, is grounded in the constitutional right of free speech, where the government grants the right of copyright to an author or a creator of an original work. I also, as an individual, have a free speech right to comment or to criticize that copyrighted work. And in the process of my criticizing or commenting on that work, exercising my First Amendment right of free speech, I have a right, I have an affirmative defense to the claim of copyright to use part of that work as necessary in order for me to express my opinion. So the Supreme Court has come up with 4 factors that get weighed when evaluating whether the fair use defense is applicable. These 4 factors that get weighed when evaluating the defense of fair use include the purpose and character of the use. That is the copyrighted work used in a transformative way? The second factor is the nature of the copyrighted work. Is the copyrighted work factual or informational, or is it a work of fiction? The third factor is the amount and substantiality of the portion used. That is, was it just a little bit of the work that was used, or was the entire work? And finally, the fourth factor is the effect of the use upon the potential market for or value of the copyrighted work. In practice, these 4 factors get balanced by the courts to determine whether the use was in fact a fair use. Now, the original question was the creator of a social media channel able to utilize the defense of fair use if their channel was monetized? And the answer to this is yes. It doesn't matter whether you're making a profit or not on your channel or your creative work. What's important in the determination of fair use is the balancing of these 4 factors. And as an example, we can take a look at the show Saturday Night Live, which frequently parodies speech from political leaders around the country. And very often, clips of these political speeches are published verbatim for purposes of political satire and criticism. And of course, there's no question that Saturday Night Live is a for-profit endeavor. Greetings from Poland. John, I love your videos. Okay, well, I'm not quite sure about that part because the comment's in Polish and I don't speak Polish. As a foreigner from Poland, an individual, can I also apply for a provisional patent application in the US? And can I, as a Polish citizen, also later apply for a regular patent in the US? So in answering your question, there are really 2 parts to this answer. First of all, anyone in the world can file a patent application in the United States Patent Office. You don't need to be a US citizen, and you don't need to be a resident of the United States in order to file a patent application in the United States Patent Office. Now, in some countries, and Poland may be one of those, you may be required to file a Polish patent application before filing a U.S. application. In the United States, for example, a U.S. inventor is required to get a foreign filing license from the United States Patent Office before filing a patent application in a foreign country. And usually, these foreign filing licenses are automatically issued some weeks after filing a provisional or non-provisional patent application in the U.S. Patent Office. But it's important to get that foreign filing license before you file in a foreign jurisdiction. Now, a second part to this question is whether you as an individual can represent yourself and file a U.S. provisional patent application as a foreign resident? And the answer to that is yes. And what I mean by this is that an individual can file directly into the United States Patent Office without using a U.S. patent attorney or a U.S. patent agent, at least for now. But the rules are changing. There's been a promulgation of a new rule, and this has just been in the last couple of weeks, where foreign entities, foreign domiciliaries, that is, people living outside of the United States, may be required this year in 2026 to hire a U.S. patent representative, either a patent attorney or a patent agent, to represent them in filing their foreign patent application into the United States. Okay, next question. This is from VC Stunts. I have an idea of a clever phrase for a t-shirt and clothing. What do you advise I do to legally patent it so no one else can duplicate this original phrase? Okay, this is a bit of a tough question. Patents don't apply to phrases, slogans, or words. Patents protect inventions, such as systems and chemical formulas and articles of manufacture. Likewise, copyright doesn't really apply to the collection of words or a slogan unless there's something stylized in the way that the words are arranged, some element of artistry or creativity. The one form of intellectual property protection that might apply to the protection of a slogan would be trademarks. And trademarks are protections that apply to the source of goods. They identify the goods with a particular company. So what are the requirements for getting a trademark registration? Well, first of all, the trademark must be attached to a good or service that is used in interstate commerce. This is very important because federal trademark law is tied to this concept of interstate commerce, or that is the trade of goods between the states. And secondly, the slogan must be distinctive and unique and have acquired a secondary meaning in conjunction with the product or services that are tied to it by virtue of its use in commerce. So if all you have is a colorful collection of words on the front of a t-shirt, it's unlikely to be protectable by trademark unless there's some tie to the company or service that's being offered. For example, some slogans that have been protected by trademark include the words "Just Do It" by Nike, or "Have It Your Way" by Burger King. And one of my favorites, "What Happens Here Stays Here" by the Las Vegas Convention and Visitor Authority. And fortunately for Las Vegas, there's no requirement that the slogan be true for it to be protectable. Okay, that's all the questions for today. If you have some questions, put them in the comments section below. We'd love to read them and I'll try to answer them for you. And if you need an intellectual property attorney for your patents, trademarks, or copyrights, you can reach me at the email address below. Thanks for watching this video. I'll see you on the next one.